Hey guys, welcome to my channel. In today's video, we're taking a close look at a tense courtroom battle where two parents fight over custody, parenting time, and the future of their children. Serious allegations, a no-contact order, and conflicting stories put everything under the judge's spotlight. But as emotions rise and both sides present their arguments, the court must look beyond the conflict and decide what truly matters most. Stay with us until the end to see how this family's situation unfolds and what decision the judge makes for the children's future.
Gabriella Gallion versus James Gallion. All right, we have motions by both parties essentially asking for identical situations where just that parenting time and child support condemned. And then this, Robert, you had filed the initial motion to adopt a parenting plan for temporary in possession of the marital residence. You filed those on June the 8th, and then Ms. Stevenson, you filed yours on the 12th. So we'll proceed with first in time, first in right, or do you want to go by the parties, whoever the plaintiffs are?
Hey, I don't have a preference, Your Honor.
Ms. Stevenson, well, you're the plaintiff, so we'll let you put on your proof first. So you wish to make an opening statement?
That is no problem with me. Good afternoon, Your Honor. Chelsea Stevenson for Ms. Gallion. As you know, there have been several motions filed that are relatively identical in nature. However, I think realistically what this case, or at least these motions, are going to hinge on is the no contact order that is currently in place. The father is currently facing charges for simple possession of paraphernalia, and domestic violence, wherein the mother is the victim, and the father was forcibly removed from the marital home after committing an alleged assault on the mother when the children were all present. During this alleged assault, the police were also able to discover several items of drug paraphernalia and marijuana and other illicit substances. Father admitted to police that they were his and that they all belonged to him and that he is a drug user. These charges are currently pending in the General Sessions Court here in Humphreys County, and there is a no contact order as a result of the domestic violence charges that forbids father from coming in or around the mother's marital residence. In the actual reports filed by the police officers in regards to that case, mother's address is listed as the marital address. She does not have any other addresses at which she can reside. And father is explicitly ordered not to come around that residence. Now, since he was removed from the home, father has paid absolutely nothing in support whatsoever for his children. He has not paid any of the bills for the home. He has not provided anything at all to mother to support the children. She has raised them entirely on her own since he was removed from the home. Now,
when was he removed from the home?
It's been more than a month, Your Honor. It's been almost 2. So, as a result,
29th of April.
Yes, Your Honor. So, as a result of this, when father first appeared in the criminal case about a couple of weeks ago, I would say, he attempted to have his bond restriction that is currently in place, preventing him from contacting the mother, removed on the basis of the fact that he wanted to speak to his children. After this was presented in front of Judge Lockhart Mash, Judge Lockhart, my client, appeared without counsel. She was only a victim in that case.
This was in General Sessions?
It's not Judge Lockhart Mash.
Not Judge Lockhart Mash, I apologize.
Judge Lockhart Mash is the circuit judge. That would have been
Judge Maples.
It was Judge Maples, Your Honor. My apologies. It was just a slip up. But either way, Judge Maples aggressively questioned my client about whether or not the children could talk to their father, and my client testified that she did not feel that it was appropriate for the father to exercise any parenting time with the minor children because they were present when the attack happened, and they are also victims of abuse at father's hands. There has been a DCS case opened in the past when father abused one of the older children to the point where he appeared at school with bruises that were significant enough to cause the teachers to call DCS. Father admitted to my client that he did hit the child. However, he said he didn't mean to hit him as hard as he did. Nevertheless, there is a long and demonstrated history of abuse on father's part against both my client and the minor children. For those reasons, we do not feel that it is in any way appropriate for him to exercise parenting time while these charges are pending against him. And that if he is ever to exercise parenting time, he should be subjected to drug testing and he should be subjected to supervision, as he is clearly a very, very violent individual who is prone to take out his anger and rage on my client and the children. It's also important for this court to know that 2 of these children are not his biological children. They are my client's biological children from a previous relationship. Only 2 of the minor children that exist in this household are his biological children. The youngest 2, who are only 1 and 2. They cannot be without their mother for extended periods of time at this age, and he has never exercised any parenting time alone with these children. Mother has always exercised the vast majority of parenting time and is a victim of father's abuse, just like the other children. Mother has also submitted a notarized income and expense statement for this court to review, pursuant to the local rules of Humphreys County Chancery Court, that states exactly what her costs are, what she makes, and what she needs. As per our income and expense statement, she has a demonstrated need of at least $3,500 a month. While we know that that may not be something possible for father to reach, as it is quite a large number, we do know that he is gainfully employed and more than able to provide the support that she needs to raise the children. Quite frankly, it was shocking to us to see a motion for exclusive possession on the home and for support, knowing the fact that father has been explicitly banned from going to this house and has paid nothing whatsoever towards the minor children's care since he's left the home. Additionally, we would assume that somebody who has abused children to this nature and is now facing charges in a court of law regarding these abuse allegations would consider the fact that this no contact order is in place for a reason. Safety and assurance that these children will be able to live happy lives unadulterated by the abuse of the defendant. We would ask that Your Honor put in an order that prevents father from contacting the minor children until the adjudication of the abuse allegations. And we would ask that if he is granted any parenting time at any time in this case, that he be subjected to regular drug testing and supervision, at least at the beginning, so that we can ensure that the children will be safe and well. Thank you, Your Honor.
Robert?
Your Honor, I don't know what case she's talking about. There are spatterings of truth in what counsel said, but far from the reality of what's going on. These parties have been married, they have 2 children. My client has not requested anything except from the 2 children. Yes, this woman has 2 other children that she's had allegations of abuse against. But again, there's no allegation of abuse of my client against these children whatsoever. I was present before Judge Maples when counsel was not, so I take significant issue with her not even being present in the courtroom stating what went on in court, because it was far from the truth about what went on. Judge Maple, I filed a motion to be relieved to modify the binding restrictions so that he could have contact with the minor children. Mrs. Gallion appeared and said, nope, I'm not willing to talk about it. Why would I give him visitation? And I'm not going to do it. And so again, it was Judge Maples did question and said, were the children, I've read this affidavit, the children were not involved in the abuse. And she entered an order that I can present to the court during the hearing, that the Chancery Court has full reign to modify the bond conditions to allow to allow whatever contact this court does as far as the children are concerned, that the bond conditions will be modified pursuant to whatever this court rules. But Ms. Gallion was using the criminal process. It was obvious to Judge Maples as well as to myself that Mrs. Gallion was using the criminal court position to position herself in this court, as many alleged victims do. There was an allegation previously Department of Children's Services that was unfounded. Counsels uniquely left that off, that it was unfounded. And again, it always is just amazing to me that someone will come before the court and talk about how someone has been abusive to these children for such a long period of time. She puts in her affidavit that they're locked in the rooms, they're doing this, they're doing that. Yet she never stood up and protected these children one time until she decides to have this child, to have him arrested. Not one time has she ever made the allegation of abuse in the past, other than the report to the Department of Children's Services. That came back as unfounded. So if a modicum of what counsel says is true, that she failed to protect these children, that her client failed to protect these children from these heinous things that she's alleging my client supposedly did, she's worse than he is, because she had the opportunity to protect and didn't do it. But I say none of it is true, Your Honor. My client works. He works at the Golf Club of Tennessee in their hospitality section. She's a waitress. He has provided care for these children. The very idea of saying he's never been alone with the children, and to have a sexist comment to state that children can't be removed from their mothers because they're 1 and 2 years of age. I mean, what century are we living in? Again, tender years doctrine was abolished in the state of Tennessee, I believe, in 1969, a few years after my birth. So that's never been the law in the state of Tennessee during my tenure as an attorney. He has provided care for the children. His father was the babysitter. He was present during this so-called abuse allegation that she took place, which she came up, jerked the keys out of his hand when he was trying to go to work, saying, "You're not taking the car." There is no allegation. My client had, as I would say, gas station drugs, perfectly legal, in the home. She lied, told the police that where they were in the home. They said, "Are these yours?" He said, "Yeah, they're mine," but there's not been any testing. For an officer of this court to come in and make an allegation that those were illegal drugs without even knowing it, I think it's inappropriate.
Objection, Your Honor. We're not here to relitigate the criminal case. These are charges that are pending before the court. It's not me or Ms. Roberts or any of our clients' job to make charges or decide what charges should be. The police decided to charge him with simple possession of an illicit substance, not us.
Based on the allegation, the sworn statement of her client stating that it was marijuana.
When I have to make a decision regarding the custody of minor children, the two parties basically are opening their lives entirely for me to examine any evidence that relates to their fitness and their credibility. So therefore, anything having to do with these criminal charges would be relevant. It goes to the issue of whether or not they're a fit parent to either have custody. So
Certainly, Your Honor.
Your objection is overruled.
Certainly, Your Honor, but the only thing that I
Your objection is overruled.
This is a different objection, Your Honor. My secondary objection would be that as counsel, it's certainly not relevant to get up in front of a court of law and say or state that she didn't protect her kids when she's a victim, or that her attorney is lying or saying things to this court that are incorrect. I'm an officer of the court just the same as Ms. Roberts is, and I did not say those things about Ms. Roberts. So I would ask that we try to stay on the facts rather than launching personal attacks. Thank you.
And your objection as to the basis for Ms. Roberts characterizing your client as being untruthful or failing to protect is overruled, because this is, again, as I've said, a case where the two of you are going to essentially try to gut each other in the courtroom so that each of you will try to show the worst aspects of the other so that you can obtain an advantage. This court's job is to look to the best interest of the minor children. And as far as any sort of personal attacks of the attorneys, I prefer that it not take place in this courtroom. But I also understand that both of you are very capable lawyers, and I will allow you to try your case. But let's keep it to the facts of the case rather than what.
And Your Honor,
Thank you, Your Honor. I appreciate it.
And Your Honor, Mrs. Stevenson is going on what her client told her just as much as I'm going on what my client told me. That's from that perspective. But when it goes into a court of law that I was there and Ms. Stevenson was not, is what I take issue with, on saying what was said when she was not present by the court. And that was the issue that I had on her stating. I wanted the court to make clear that she was not present in the court and witness, and that Judge Maples specifically ruled that the residential.
I'm going to decide this case so that everybody understands. Right. I'm going to decide this case based on the evidence before me today and what I find to be the best interest of the minor children. It is not going to be decided based on what another judge has or has not said or has not heard. It will be heard and decided by me from the witness stand today. And while statements of lawyers and their opening statements are allowed to try to give me an idea of what their case is going to be about, the statements of lawyers are not evidence. Neither Ms. Stevenson nor Ms. Roberts' statements are going to be, I'm speaking to your clients now, neither Ms. Stevenson or Ms. Roberts' statements to me about what has or has not transpired is going to be considered by me as evidence. It is their indication of what they think the case is about and what they want me to do. I'm going to decide this case based on, you put it in my hands, I'm going to decide it based on what I think is the best for your children. And neither one of you may like what I do at the end of this day. But we will go forward from that. Ms. Roberts, anything further?
That's it, Your Honor. And again, what we're requesting, again, if she's going to get possession of the home, she needs to pay for it. He will be entitled if he gets possession of the home. He will get it. There has been no ruling of the General Sessions Court on who has possession of the home. So I want to make that clear. The court has not ruled who has possession of the home. It's wherever she's living. The General Sessions Court has sole province about a no contact order with her. I do not disagree with that. But all of the other issues are not before the General Sessions Court. And any indication that they are is incorrect.
All right, Ms. Stevenson, is the rule requested? The rule has been requested, then we'll need to have anyone who's going to be a witness other than the parties go outside of the courtroom and remain outside of the courtroom until you are called to testify. You're not to discuss the testimony of any other witness until you yourself have testified. Counsel are under continuing duty to ensure that that rule is complied with.
And Your Honor, we just have one more concern that we'd like to address. Pursuant to the local rules of Houston or of Humphreys County Chancery Court, we were supposed to each have filed a notarized income and expense statement as well as a copy of our proposed parenting plan, and we have not received either of those things from the opposing party. It's difficult for us to move forward and decide exactly what support amount is appropriate if we don't have any sort of statement that is detailing what he makes,
Ms. Stevenson, that is a rule that is in the local rules, but it is a rule that is more observed in its breach than in its compliance. So it's not unusual to have that situation happen. I will take a recess for you to discuss with Ms. Roberts if that information is available, and that will give you an opportunity to prepare. We'll take a 15-minute recess.
Great, thank you, Your Honor.
All rise. I'll get it to you. We have got the
Be seated.
Your Honor, thank you for giving us a break. We've reached a tentative agreement in this matter, subject to court's approval. What we're going to do, Your Honor, is that Ms. Stevenson and I are working towards trying to get a global settlement of this case taken care of. But again, we've got the criminal charges that are pending that need to be resolved. So what we're going to do, Your Honor, is that today, Mr. Gallion is going to be able to see the kids at the home beginning at 1 o'clock for 2 hours. His father's going to accompany him. He's going to visit in the home. The babysitter's going to be there. Ms. Gallion is not going, right? Where you go?
She'll be there, yes.
So the bond conditions will be modified that he can exercise visitation at the home, and that will not be a violation of the bond conditions. My client is going to voluntarily sign up and take an anger management class. He's going to get that signed up today. I'm going to provide that proof to Ms. Stevenson. She's meeting with her client, and we're going to work towards getting a more expansive residential schedule. We just need to coordinate my client's off, his days off, when she works, and sometimes she has to work late. So we're going to try to coordinate that. And so we're going to try to get that done, but in the event that we can't do that, we're passing this case to July 10th so that we can try to get a global settlement. As far as the home is concerned, Mrs. Gallion is going to make a concerted effort to see whether she can purchase the home and buy Mr. Gallion out. She's going to see if she can do that in the next 7 days. Mr. Collier, presently, I'm going to contact him, give an appraisal of the home. Because again, neither one of them want to sign a year's lease if the other one's going to buy, because my client would like to buy the home out if she's not, but she's going to get the first option. If she can buy him out, that's great. And then he'll need to get a more permanent residence. But if she can't, he's going to purchase the home, and then she can understand and have time to get that. So that's one of the reasons why we're trying to get this passed a little bit. The bond conditions are going to be modified. Their youngest child is having a medical procedure on the 8th. And so we're modifying the bond conditions that says that it's not a violation of the bond conditions for them both to be present at any medical appointment or procedure of either of the children, of their children. And then we'll work towards getting that, and then get the bond condition modified that while the criminal charges are going, he cannot, and just reiterate on the record so that he understands, he cannot have any communication with Mrs. Gallion directly. They're going to meet today at the home, and then Ms. Stevens and I will probably enter supplemental order that they can meet to exchange the children, and that they can, what I would suggest is through written communication, keep each other apprised of the physical condition, doctor's appointments, things like that. I'm going to suggest a parenting app that they can communicate through so that it's a record, and then hopefully we can get the criminal charges resolved and we can have a more full hearing on that matter.
Yes, and Your Honor, I just want to mention, the only reason we're not giving you the full schedule today is just because our clients have unique work schedules, and so we need just a minute to sit down and think about it. But otherwise, they
both work in the hospitality area, and so their schedules are not a Monday through Friday 8 to 5 type scenario. So we're trying to coordinate that, and we both need to get those schedules. He's been able to get another day off, and so I need to communicate that. So that's what we're trying to do.
Well, I'm happy to approve the agreement that's been reached between the two of you, and I'm glad that you were able to resolve that through your lawyers. Let me just say a couple of things to you right now. And Ms. Roberts has heard me say this before, but I'm going to say it again. Your children have two parents, not just one. And while we have a situation that has arisen where the father has created a situation allegedly where Mr. Gallion is not being allowed to see the children. Right now, those are just allegations. I understand you know what happened, and Mr. Gallion has his version of what happened. But the fact of the matter is that you have two children together, I think, and then you have some other children. But right now, you've got to focus on what's in the best interest of your children. If you have issues, and obviously there was some sort of problem, there usually is fire where there's smoke. If there is a situation that has arisen simply because you let your temper get away from you, you need to address that. If you want to be a part of your children's lives, you need to fix the problems that are keeping you away from your children. If that is your anger issues, then voluntarily signing up for anger management classes is the best way to do it. Find a way to address those issues. If the two of you were not going to be together, then you need to find a way to tolerate each other down the road. Once the criminal things, all of these criminal things are subsided, you need to find a way to tolerate each other and to be able to be nice to each other. One way to do that is at some point you two had feelings for each other that led you to get married and led you to have children together. Whatever those feelings were, if you could try to remember them and try to recapture some of that and let this anger and hostility that's existed. But children need to grow up in a home without the threat of violence, without the threat of arguing and fussing and fighting. They need to have a stable environment. And if you can supply that for them because you get some help, then that's what we want. We want the children to have their father in their life. But by the same token, Mrs. Gallion and those children deserve to live in a situation where they're not walking on eggshells and worried about when dad's going to lose his temper and blow up again. They're not going to worry about, they don't want to have to worry about whether or not there's going to be some sort of an abuse and so forth. So it can be done. I can tell you that there are many instances where people have gotten their lives straightened out and they've gotten things taken care of. But we're going to do it according to your lawyers. You both have good lawyers and they're advocates for you and they'll give you advice. But the idea is to try to move you towards a more normal type situation so that your children can grow up together with the two of you co-parenting. Because if you don't, if this continues with that anger and hostility, you're going to basically ruin your children's lives. Think about it from now. If you were a child and you knew that mom and dad hated each other so badly that they couldn't even be together unsupervised, then they're going to grow up dreading every major event in their life, every birthday, every Christmas, every other holiday. When they get old enough to start graduating, they have graduations from kindergarten, from 5th grade, from 8th grade. They do a lot of graduations now. They're going to want you both there, but they're not going to want you both there if they're afraid that you're going to argue and fuss and fight. I see cases all the time where mom and dad can't even get along well enough to be at the same soccer field or the same baseball field. And you know who suffers in that situation? Your children. And having your children suffer is not what this court wants to see happen. So, keeping on with that analogy, eventually your children are going to get married or graduate from college, maybe graduate from high school. They're going to want you both there, hopefully. They're not going to want you both there fussing and fighting, because if you have the attitude that you hate each other so badly you can't even tolerate each other, you're going to not do anything but ruin those events for your children. They're going to be stressed, they're going to be anxious. And so I'm just suggesting that she has every right to feel that if you've been abusive towards them, verbally abusive or whatever it's been, then she has every right to expect that you're going to have to change your ways before the children can have an unsupervised situation with you or can be, safe with you. She has every right to feel that way. You have every right to think, I'm going to be the father that my children deserve. And if you are going to be the father that your children deserve, then you need to make the changes necessary to prevent anything else from happening. All of this is saying I'm not assuming any facts because I haven't heard any of the evidence. I'm not assuming that any of these facts are true, but I'm trying to get you both to start thinking from a different perspective, to think about what's in the best interest of your children and down the road what's in their best interest versus what's necessarily going on right now. Anyway, I'm glad you were able to reach an agreement. I hope you'll take what I have to say and maybe understand that my only desire is to try to see that your children are well cared for and that they're protected. Because I can tell you from personal experience that growing up as a child, when you have a lot of that going on in your life, you remember those days. You may not remember much when you were the age of your children, but you can remember things that happened to you when you were that. My dad was pretty angry and abusive World War II veteran when he was younger, settled it up, got control of everything, quit drinking, and became an established member of society in our town where we grew up, and people would have never believed that he would have been like that. But you know what? I remember what it was like when he was angry, when he broke up furniture, when he did things that has all of the 5 children hiding from him because of that. So you want that kind of memory for your children? I didn't think you would. So that you need to fix it right now so that you don't have that. All right, then who's drawing the order?
I'll draft the order and submit it to Ms. Davidson for her approval, and then we'll do it. She can do the next one.
All right, then I will approve your agreement, and it comes in order to the court today, even though it's not a handwritten order yet, not a typewritten order yet, it is an order of the court.
Thank you, Your Honor.
Thank you, Your Honor. I appreciate it.
We stand adjourned until 9 o'clock tomorrow morning when I have a criminal docket.
All right. I'm sorry, that was my fault.
Okay. This is.
This case highlights just how complicated and emotional family court matters can become when trust is broken, serious conflicts arise, and children are caught in the middle. Throughout this hearing, both sides presented their arguments, with one side raising concerns about safety, past incidents, and the need for protection, while the other side challenged those claims and asked the court to consider the full picture. The judge carefully explained that the court's main responsibility is not to take sides in personal conflicts but to focus on what is truly in the best interest of the children. Safety, stability, emotional well-being, and having a healthy relationship with both parents were the central concerns discussed during the hearing. The court recognized that allegations must be handled through the proper legal process, and decisions cannot be based only on accusations or arguments made in court. At the same time, the judge reminded both parents that their actions and choices directly affect their children's lives. Anger, hostility, and ongoing conflict can create lasting emotional damage, while cooperation, accountability, and positive changes can help children grow in a more stable environment. The court encouraged both parents to work toward improving communication, addressing personal issues, and finding a way to successfully co-parent for the future of their children. This hearing serves as an important reminder that family court is not only about winning or losing a case. It is about protecting children, creating a safe environment, and helping families move forward despite difficult circumstances. If parents are willing to accept responsibility and make necessary changes, they can build a healthier future for themselves and, most importantly, for their children. If you enjoyed this video, don't forget to like, comment, and subscribe. Thanks for watching, and I'll see you in the next video.